We just announced on Monday that the Supreme Court will be taking on a Second Amendment case for the first time in over a decade. So we're going to take this video and we're just going to focus on why we believe that this case is going to open up wide constitutional carry from state to state. We're going to look at exactly the decisions the courts have made in the past and why this decision is so incredibly different. Let's just start off by this case. This is the New York State Rifle and Pistol Association versus Corlett. Now, what this is in regards to, and I'm just going to read this straight off of the Supreme Court's website. This is a case scheduled for argument before the Supreme Court of the United States during the court's October 21 to 22 term. The case: Robert Nash and Brandon Koch each applied for a license to carry a firearm for purposes for self-defense pursuant to New York Penal Law 400.00. The licensing office denied both Nash's and Koch's application, finding that neither individual met the proper cause standard required by New York law before issuing firearm licenses for general self-defense. Now, the question that they're going to address, because this isn't just a broad, it's less broad than one might think, but the results are going to be incredibly broad, and we're going to continue to talk about that, so stay with me. The question being presented: whether the state's denial of petitioner's application for concealed carry licenses for self-defense violates the Second Amendment. Great question, and I'm glad they're addressing it. So here's kind of what we see as, and we're just looking at law, we're just looking at case law specifically, looking at how judges, the current Supreme Court judges, have voted in the past, and we're going to throw out packing the court and stuff like that. This is this current term. I mean, they're not packing the courts before this case will be heard, that's for sure. The only way that what we're about to talk about would change is if a current Supreme Court justice resigns or passes away. So what's basically taking place here is that New York State handgun licensing laws have been in place since 1913. And what they do is they require licenses to carry handguns, and that burden and carry is in the hands to be demonstrated by the carrier. So if I want to carry a gun in New York, I have to show New York State, I have to prove that I have, and this is in quotes, proper cause to be able to carry. Most do not get approved. Denial list is much longer than the approved list. So what can I get approved for? Let's start by that. Hunting or target. Now, if I go to New York State, I want to apply for a handgun permit to carry a handgun for hunting or target shooting, there's a chance I'm going to get approved, but then I can only possess that handgun in my home or if I'm hunting or target shooting. There's a few other reasons outside of that, but they, like if I work for the police department, if I work in security, or in some cases if I'm like a storekeeper in a rough part of town, I may get approved. But outside that, that's it. And even if I did get approved, it's only for that store. I can only carry it at that store. I can't carry it anywhere else. And some storekeepers do get that approved, but again, I can't carry it anywhere else other than my store. Now, they do offer unrestricted licenses, but good luck, you're not getting one of those. Outside work, you have to prove that you are in danger of some sort, and then they may give you a temporary unrestricted permit, but what that's I essentially have to prove that I have somebody trying to kill me, like a stalker that's been designated by the courts. So like if the courts show that there's somebody after me, then I might get a temporary permit if they are not in police custody, and then as soon as they're in police custody, then that is a done deal. But if you just want to carry a gun for protection, no way. There's no way that you're going to be able to do that in the state of New York. So the argument from a few that have been denied, that's kind of where we're at, is there's an argument of just a few that have been denied, but it's going to open up the entire country. Why? 6-3 vote in the Supreme Court. Now again, I know a lot of your guys are skeptical about 1 or 2 justices, but let's look at how they voted in the past. You can't just say, well, I don't like this guy, so he's going to vote a certain way. You got to look at how they voted in the past, and that's what we're going to take a look at here. So what this case will do is allow the Supreme Court to broaden this coast-to-coast constitutional carry, because if they deem that these guys are eligible to carry and that they violated their Second Amendment, then of course that's going to apply in other states as well. So let's kind of look at this. In 2008, the last time that the Supreme Court saw a case was the District of Columbia versus Heller. Now it's very critical you see how everybody voted in this case and what this case was and the discussions that took place between the court justices during this time. What this case held was that that carrying a gun was not only for militia, because a lot of states would say, well, the Second Amendment says you got to be in a militia. And that's not like the militia that many of you are probably in. We're talking a state-regulated sort of militia, kind of like the Homeland Security or that kind of thing. That those types of people had the right to bear arms. Well, in 2008, they overturned that. They said, no, this applies to the average citizen. Now, this Heller case also, so they struck down the DC's ban, first of all, on handguns outside of the home. That's a good thing. The Heller case also allowed states to not allow CCW if they chose. So there are some states that don't allow concealed carry. Now, they have to allow you to carry. It just doesn't necessarily have to be concealed carry. It also said no firearms for felons, mentally ill, forbids carry of sensitive areas like schools or government offices, and that you're not allowed to carry dangerous or unusual weapons. And I'm not really sure what that means, and that's a very broad argument that some Supreme Court justices that we're going to talk about shortly have argued against as well. So here's the big problem with the Heller case. Yes, it said, no, you got to let people have handguns. You can't do that, DC. But the lower court's interpretation of these laws are just, and state lawmakers, by the way, are all over the place. There's so many crazy interpretations that can be made with these cases. And most lower courts have adopted state rules for the most part, and the Supreme Court hasn't even decided to argue against what these crazy state laws like California, New York, Jersey, Oregon, Washington, Illinois. We're going to add a few more to that now, but so why is it that they're now taking this case? So why are they finally doing this? Now, let's look again. I know a lot of you guys say, oh, they're going to pack the court. They're not going to pack the court this session. If they're going to pack the court, it's not going to be anytime soon. That's for sure. In 2011, Brett Kavanaugh, while a lower court judge, struck down a law banning the carrying of AR-15s. That was huge in that lower court. The cities and the states were banning the carrying of AR-15s openly, or as a, he struck that down. That's good news. So now we got Brett Kavanaugh on. 2019, Amy Coney Barrett essentially dissented by showing non-violent felons should be able to carry. So essentially, if they're like, like they have some sort of postal violation from the post office for some sort of mail fraud or something, like they should not be stricken down from being able to carry. The real reason that this is going to open up Second Amendment carry from coast to coast is that in 2019, when Justice John Paul Stevens retired, he revealed, and this is critical, that in the Heller case in 2009, when Antonin Scalia, who authored the DC versus Heller case, when he was circulating his draft with the justices, that former Justice Anthony Kennedy asked him for important changes. And that's a quote, literally, important changes in this. And because Heller was a 5-4 decision, he needed Kennedy. He needed that vote to hold the majority. Otherwise, he was going to lose the whole thing, and that would have been a hot mess. So what he threw in, and this is in quotes, this is what was thrown into that because of Kennedy, that Heller should not be taken to cast doubt on existing state laws. That's huge, and that's why we're in the trouble that we're in right now. And that it only allows states who allow carrying in public to not limit it to militias is really all it did. So ultimately they're saying that you can carry if you're not in a militia, but state laws still apply to you. That was the problem with the DC versus Heller, because a lot of people, well, hey, it says it. Why shouldn't we be able to carry? That was the problem. You got to look at the fine print in this decision. Now, just recently, Kennedy retired and was replaced by Kavanaugh. Justice Ginsburg just passed and was replaced by Amy Coney Barrett. And the very near future of gun control, in my opinion, looks very, very bright. You know, even in 2009, it was this close. It was literally to the point where we had one justice who is gone now, essentially say, well, we don't want to tread on states' rights. And as a result, it treaded on our rights as the citizens. Now, I'm very fortunate. I'm in the state of Missouri. We don't have any issues here. We have constitutional carry. Now, one thing I will say is they did open it up for interpretation by the cities, that the cities can choose open carry or concealed carry or both if they want. So like the city I live in, they don't allow open carry. That's fine with me. I don't open carry. I conceal carry every time. Unless I'm in a state that doesn't allow concealed carry, then I open carry. But there's states, like, you know, again, like New York. I was just in New York City. It's awful to walk around that town without a gun. It's ridiculous. This is good news, and in my opinion, you're going to see, you know, again, I'm not a Supreme Court justice, thank goodness, but overall, you know, if I was a gambling man, which I'm not, I'd put my money on constitutional carry coast to coast this time next year, if earlier. So there you go. There's kind of why I believe this is going to go forward. You know, a lot of people, when I posted that video on Monday, said, well, you know, hey, you know, this justice this justice that. You have to look at how they vote. You can't just not like a guy and say, well, then he's just going to vote the wrong way because I don't like him. You have to look at how they have voted, and in Second Amendment cases specifically. You might not like the things they said about recent cases. I'm talking Second Amendment cases only. The DC Heller case in 2009, even though it was leaning liberal, still passed, but they gave states that freedom to do that. So it was really, it's kind of a win and a loss, thanks but no thanks kind of victory. This one is going to be very, very clear cut. They give those two guys the right to carry in New York. They give the rest of the country the right to carry. Love to hear your thoughts on it. Put it in the comments below. If you like this video, click like and subscribe. If you feel called to support this channel through Patreon, that link is also below. But the most important part of this channel is we take prayer requests. Never hesitate to send that in. Thank you for watching this episode of God, Family, and Guns. And as always, love God, love your family, love guns.